As she got off her wheelchair, I realized that there were two small steps which prevented her from seeking access to the place of justice, and somebody had to lift the wheelchair and bring her in. But those two small steps led to the creation of a ramp, and then we have put into place an accessibility committee of the Supreme Court, which has given its report, which we are now implementing. The barriers for mainstreaming every individual in society are not born either in the medical conditions of those who need to be included. They are not born in any other area other than our own minds. Cooperative efforts such as this conclave would certainly take us closer to Abhidi's idea of India and go a long way in building better and fuller public lives for persons with disabilities. I have a prepared text, and I think I have to speak to you as Chief Justice of India, because I've been invited not so much as a person as for the office which I hold. But before I speak to you as the Chief Justice of India from my prepared text, let me speak to you as a human being. Of course, Chief Justices are also human beings. We are all shaped and reshaped by the universe in which we live, and by the felt experiences which we gather over a whole life of the experiences which we encounter. So I'll share with you some of my own experiences in navigating this area that we are all here to debate and discuss this morning. As my sister Nagarathna mentioned, my spouse Kalpana and I are parents to two lovely children, Priyanka and Mahi, both of whom have a condition called Nimilian myopathy. They are both wheelchair bound. They began schooling for the first time when they came to me, and my destiny took me to Delhi. They belonged to the state of Uttarakhand. I'd never been to a formal school because there was no school in the village. But when we moved from Allahabad to Delhi, we tried our best to find a school for them, thinking that they had to go to a special school. Allahabad had only one special school which closed down when the good person who ran the school passed away. So there was nobody in Allahabad except for a few pastors and people from the church who would come home and teach them a few alphabets. So they went to Tamanna, run by the redoubtable Mrs. Chona. But soon we realized that they were not meant for a special school because they have a problem of a muscular condition, but their minds are razor sharp. But I can spend the whole day talking about little Priyanka and Mahi. They're now no longer little, they are 16 and 14. They're both wheelchair bound, navigate themselves independently. They don't like to be assisted. Mahi told me a few months ago that she wants to come and see the place where I work in. So I said, hop into the car and we'll go to the court in the morning. As she got off her wheelchair, I realized that there were two small steps which prevented her from seeking access to the place of justice, and somebody had to lift the wheelchair and bring her in. And I quite didn't like the fact that somebody had to lift the wheelchair and bring her in. But those two small steps led to the creation of a ramp, and then we have put into place an accessibility committee of the Supreme Court, which has given its report, which we are now implementing. I wouldn't speak too much more about my experiences of life, which I've gained from Mahi and Priyanka, but I can only tell you that they have completely changed my universe of existence. Little Mahi is the reason why I have been turned into a vegan, because she's a fierce environmental activist. She's an animal rights activist. Both of them are amazing photographers. And they take pictures in our garden of birds in different moods and different shades of the day and the evening. But both of them have persuaded me to adopt a lifestyle which is cruelty-free. Not just in terms of eating vegan food, because being a vegan is not just about the food that you eat, but the lifestyle that you live. And to adopt a lifestyle in which you don't accept or support cruelty to any living being in any form whatever. But I'll leave Mahi and Priyanka alone for the moment, as they are in Delhi with my wife. But I was reading the other day about this tweet by an IAS officer from the state of Telangana, who was wondering why you should have differently abled individuals in the civil service. And she said that, how can an IAS officer do the work of a civil service officer if you are not, quote unquote, mainstream? And she said, if I had a physical problem, would I ever go to a surgeon with disability? And I said to myself, that's why I began by telling you that our universe of experience shapes our ideas and the way we evolve as persons. And I'll share a personal story in response, not an abstract theory like what judges are prone to speak. I was the spouse to someone who was a cancer survivor for almost 12 years, until my late former spouse passed away in 2008. Now, when she was undergoing chemotherapy, the leading expert from the world of chemotherapy in India, Dr. Suresh Advani, came to the Jaslok hospital in a wheelchair. So the answer to the question as to whether I'd go to a surgeon if I had a problem and the surgeon suffered from disability, I would only point out the example of Dr. Suresh Advani, a living example of a person who is renowned worldwide for his expertise in chemotherapy. And he incidentally performed the first stem cell transplant in India. So much for not having differently abled persons in the civil service. We made history in the Supreme Court on the 6th of October 2023, when a young deaf lawyer, Sara Suni, requested me that, well, I want to address the court. And how would I address the court if I don't follow which my opponent says or what you say as a judge? And that led to us having the very facility which we have on the dais this morning of someone explaining to people who have hearing impairment on what is happening in the Supreme Court. As part of your session today, you have as one of the participants, Rahul Bajaj, a young blind lawyer. Rahul joined my chamber as a law clerk several years ago, a young Rhodes Scholar who thought that instead of completing his PhD at Oxford, he should rather see the real life experiences of the Supreme Court. In so many which ways, my interaction with Rahul changed my own perception of the way we view people who suffer from, or not suffer from, but are born or are impaired. In so many which ways, Rahul's engagement with the registry of the Supreme Court, with judges of the Supreme Court, has changed the way we as judges have tried to make ourselves and our institution more accessible to persons with disability. I've been chairing the E-Committee of the Supreme Court for the last 5 years, and the E-Committee has adopted 6 accessibility parameters: High Court websites, access to judgments, access to cause lists, access to case status, contrast and color themes, text sizes, screen reader access. We have moved from a purely visual capture to an audio capture. And we have worked with the National Institute of Visually Handicapped and the National Association for the Blind. 28 batches have been trained across India. We have 558 visually challenged staff in our district judiciary who have been trained by the staff at the E-Committee. Somebody spoke about my recent judgment in Aankh Micholi, that was the name of the movie, where we laid down parameters for representation of the differently abled in the visual media. Well, the film had excerpts it had not disability humor, but humor which completely, in that sense, was pejorative to the differently abled. They referred to a person who had a forgetful memory, perhaps suffering from dementia, as a bulakkad. And I said to myself that, well, my mother suffered from dementia in the last few years of her life, and she was suffering from Alzheimer's. Would I call my own mother bulakkad? It called a person who suffered from a stammer as an atakti hui record. That was supposed to be humor. And I said to myself, they had to only read about the life story of Mr. Nani Palkhiwala, one of the greatest lawyers ever born in India, who was born and suffered from a stammer for several years of his initial life, and then became one of the most eloquent lawyers that the country has seen. So these are just a few examples which I thought I must begin by sharing with you, that in a sense, the barriers to inclusion, the barriers for mainstreaming every individual in society are not born either in the medical conditions of those who need to be included. They are not born in any other area other than our own minds. And it is only by engaging with others, by understanding the perspective of others at conclaves like this, that we can, in that sense, truly move ahead into a more inclusive and dignified society. Having now spoken to you from my heart, let me now speak to you as Chief Justice of India. First and foremost, I want to thank each of you for your presence at this summit. The disability rights movement in India is a product of the toil and industry, not only of lawmakers, lawyers, and judges. It has been shaped and enriched by those who worked at the grassroots, pushed the boundaries of access and inclusion in their respective institutions, and overall made this world a more diverse and equal place. This conclave marks a continuum of these efforts, and I look forward to your outcomes and deliberations. It is truly a pleasure for me to deliver the inaugural address at the India Accessibility Summit and State Disability Commissioners Conclave of 2024. Normally, it's a matter of etiquette that you say your pleasure and honor in speaking at these events. But for me, it is truly personal, because as a father of two differently abled children who have been part of my existence since 2014, I've really learned so much, more than what I have given to these two little children who are part of our lives. Institutional efforts to address systemic inequalities and create a level playing field for all our citizens are essential. Such efforts are embedded in the very spirit of our Constitution. The preamble to the Constitution declares at the very outset that we have solemnly resolved to secure to all our citizens justice, liberty, equality of status and opportunity, and fraternity, assuring the dignity of the individual. So there you have the very essence of the movement for inclusion within the text of the Constitution. Part 3 of our Constitution specifically carves out finer elaborations of these rights. But the reason these values find their way into the preamble is that they brood over our constitutional political, and legal conscience. They dictate the terms along which constitutional bodies, functionaries, and all other institutions are to arrange themselves. As institutions, we are intricately tied to the citizens' public and private lives. Percival Spear, a British historian, wrote that at the time of our independence, independence had been an ideal, a desideratum to be worked for. Now it was an axiom of public life. The quality of our public life and those who shape it decide the contours of independence. As functionaries of public and private bodies, we impact everyday lives of our citizens. Our laws, policies, and institutional priorities shape, to a great extent, the exercise of our independence and its quality. For instance, we did not deem disability as a legislative priority for almost 4 decades until 1995, when the Persons with Disability Act 1995 was brought about. Even with this law, our understanding of disability was somewhat strained. We were still locating the issue in individual bodies and exempting social barriers as the cause of the problem which persons with disabilities faced. This was until 2016, when the Rights of Persons with Disabilities Act took a deeper look inwards and identified the social and institutional barriers as a cause of disability. This meant we needed to work on enhancing our preparedness to accommodate persons with disabilities in public life and minimize barriers to their access. We could not simply pathologize the individual with the impairment and consign them to a life of isolation from the public sphere. We are now under a duty to build better, inclusive public lives for our citizens. These laws followed in the footsteps of the International Convention on the Rights of Persons with Disabilities. Legal framework aside, our architectural models, intellectual resources, and choices of physical or institutional design sometimes adopt a singularly ableist perspective. The law now identifies that these barriers create disabilities and exclude persons from equal participation in social, economic, and cultural terms. My little Mahi is extraordinarily fond of science. What do you say to her when she comes home one afternoon from school and says, "I can't go to the science lab because the science lab is located in the basement, and there is no way for me to access the basement in a wheelchair"? So what that little child said in the skit was not part of just a skit. It's true about real life. And what do you tell the child? And what do you tell the parent? The parent can, of course, empathize with the child, but what do you tell the parent? Underrepresentation of persons with disabilities due to these barriers in educational institutions, the workforce, and decision-making bodies also excludes them from public discourse. This, of course, violates a whole range of their civic rights, compromises their citizenship and fundamental freedoms. This exclusion also robs our public discourse of valuable inputs. We are left with a deluge of ableist perspectives that overcrowd our social conscience as a nation and weigh heavily on the way we see the world. For instance, a 3-inch high entry threshold or narrow lift doors would hardly strike a non-discerning eye as problematic features of a building. Our default lens of assessing everything, from the physical infrastructure to professional expectations to the idea of merit, is skewed. In a book called Invisible Women, Caroline Perez highlighted a US study indicating that as opposed to a staggering 40% of women Only 17% of men left their tech jobs. This, she noted, was due to a lack of adequate support systems and institutional biases at the workplace. This, she says, is the male default. She calls it the male default, a social phenomenon where the decision-making tables are overpopulated by male perspectives. Similarly, our physical infrastructure as a nation and some of our policy considerations are ableist. They stem from a lack of participation, and they also further entrench the lack of participation of persons with disabilities, forming an endless loop of exclusion. I frequently come across reports of persons with disabilities struggling to find wheelchairs and assistance at airports, restaurants, and other public and private spaces. As we discuss finer issues of implementation of policy, realization of rights to dignified lives, we must ask ourselves how each one of us got into this room today, and whether some of us had to work harder than the others to take their rightful seat at the table. The CRPD, that is the Convention of the Rights of Persons with Disabilities, and the 2016 Act thus lay great emphasis on participation. Greater participation would mean better engagement with issues, a more nuanced understanding of our flawed systems, and a shift in perspective towards persons with disabilities. For instance, a report in Vidhi, Center for Public Policy, about urban planning and institutional design, it was revealed that the 3% reservation in poverty alleviation programs under the 1995 Act was remarkably successful in the state of Karnataka. This was due to the participatory governance and disability policy of the state government here in Karnataka. This policy promoted participation by implementing self-employment programs, wage employment programs, food safety programs, and social security programs. Indian corporate institutions have led by example in creating diverse workspaces. In India, corporate social responsibility led the way for inclusive hiring practices. Some of the HR policies tied managerial performance with diversity of hiring choices they made. While they began as a ticking of the box legal compliance, such hiring practices are now just better economic and institutional choices. Trite ableist notions stand debunked with contrary evidence of the stellar performance of those who are hired. The brief for today's event has a promising lineup of themes and topics to be discussed. I believe what struck me as the most powerful underlying issue, which also in a way justifies the diversity of participants in this conclave, is the horizontal nature of diversity. A majority of us do not imagine a wheelchair-bound person when we think of a colleague. We do not think of someone with full or partial visual impairment when we imagine a data scientist or a lawyer or a teacher. A judgment of the Allahabad High Court said somebody with a visual impairment cannot possibly be a judge. Why? The rationale was that somebody who is blind will never be able to understand the demeanor of a witness whom the trial judge has to see. I overruled the judgment several years later. But the perspective that someone who suffers from a visual impairment will not be able to analyze the demeanor of the witness is so untrue. Perception is only partly a function of what you see. Perception lies beyond what you visualize through your eyes. Ask me as a judge, and I know that what I read with my eyes in the black letter of those dry paper books tells you only a part of the human story of the case before you. Our lives abound with instances where persons with disabilities are not directly addressed. These may be fleeting moments to us, but this sense of not belonging in a place permeates the entire lives of persons with disabilities. Judy Heumann, better known as the mother of the disability rights movement in the United States, whom we lost earlier this year, had to mount a legal battle simply to teach. Ever so gritty, she proclaimed that she would teach on the ground floor if the school lacked a ramp and an elevator. A lifelong champion of accessibility measures in public places, she also believed that accessibility was more than ramps and elevators. It was about recognizing that all of us needed support systems across the spectrum of experiences ranging from education to employment to healthcare to recreation. I have had little children come to me and tell me, "Uncle, I can't go to the swing in my school because that swing can be accessed only by children who don't sit in a wheelchair." I believe conversations about disability are incomplete without acknowledging the various kinds of disabilities. Invisible disabilities or non-visible disabilities, NVDs, as the name suggests, are harder to spot. They are equally harder to obtain support for. Studies show that a majority of people with NVDs choose not to disclose them, fearing stigma and bias at workplaces. This stigma stems from our perceptions that disabilities are deficits. Rosemary Case, a former chair of the UN Committee on the Rights of Persons with Disabilities, has long advocated for a human rights approach to the systemic challenges faced by persons with disabilities. She argued that viewing disability as a deficit promotes discriminatory parallel systems for education, healthcare, and justice. When we create such systems, we place those without disabilities, at least visible ones, on a pedestal and assume that they are the normative ideal. We wrongly assume that some of us possess the elusive, complete repertoire of human abilities, while the rest are anomalous exceptions. This delays the diagnosis of serious NVDs and compels people with NVDs to conceal them and suffer in silence. India has one of the largest populations of persons with autism and development and neurological conditions in the world. A 2014 report in the Economic Times found that 71% of children with disabilities lived in rural areas with fewer support structures. Active diagnosis, education, and awareness campaigns will go a long way in overcoming the stigma and prejudice around NVDs. Earlier this year, the first ever national conference on invisible disabilities marked a significant leap in the direction of tackling these silent struggles some of us may be facing. Our Constitution does not specifically mention disability as a proscribed ground for discrimination, but the Supreme Court has clearly held that the constitutional rights and protections inhere equally in persons with disabilities. The jurisprudence on the rights of persons with disabilities has evolved from negative, non-discrimination rights to positive, affirmative duties on state as well as private persons, ranging from non-implementation of the law, discrimination in service rules, and denial of support facilities such as scribes in examinations and wheelchairs at airports. The Supreme Court and the High Courts are frequently the sites of some of these battles. As an institution of justice, we are also cognizant of our accessibility limitations. The Supreme Court's E-Committee has consistently worked towards leveraging technology to improve our practices and procedures. We recently undertook an accessibility audit of the Supreme Court premises. The Committee on Accessibility suggested a slew of measures, such as instant audio transcription of proceedings, digital document access, and a dedicated mechanism of accessibility applications to ensure accessibility of documents, assistive learning devices that amplified sound and reduced background noise for parties and counsel with visual and hearing impairments. We have undertaken similar measures for assessing the infrastructure of our state and district judiciaries and collected data on physical and technological measures for accessibility. I've had the opportunity to examine in some detail what accessibility means in my profession. A citizen's interaction with the law is nearly always mediated by a host of legal functionaries before they can meaningfully state their case to a judge. Accessibility for us means accessibility to legal procedures and outcomes, dedicated infrastructural facilities, as well as technological aids such as closed-captioned live streams, OCR-enabled judgments, hyperlinked cause lists, and engaging sign language interpreters for advocates or parties with hearing impairments are some of the measures that we are relying on. Standing as I am in the IT hub of the country, I must confess that I feel as though I am showing a candle to the sun, discussing the gains of technology in accelerating access. We have a lot to learn from each other's experiences in institutional design, architecture, and regulatory frameworks. The Disability Commission data reveals Karnataka is among the front runners in creating public employment opportunities for persons with disabilities. The State Disability Commission is implementing a grant of maintenance for caregivers of persons with disabilities. The Urban and Regional Development Plans formulation and implementation guidelines issued by the Town and Country Planning Organization and the state guidelines modeled after them are crucial. They recognize the need for barrier-free access to public places and participatory development planning. The state urban planning laws in various states have recognized accessibility standards for public buildings. There is a marked shift in the way we approach disability today. Training academies and administrative officers have dedicated modules for disability sensitization. State commissioners in some states are organizing public meetings to improve service delivery and inform policy making with lived experiences of people. Dedicated clinics at universities, such as the Center for Disability Studies at Nalsar at Hyderabad, policy think tanks such as the CLPR, Vidhi Center for Legal Policy, NGOs, and many other independent and sponsored institutions have enhanced our understanding of the ground realities about accessibility. Private corporate entities have shown great initiative in promoting endeavors ranging from research grants, corporate social responsibility contributions, and inclusive hiring practices. Initiatives such as Mitti Cafe are constantly challenging conventional wisdom about labor force participation of persons with disabilities. Following the setting up of Mitti Cafe in the precincts of the Supreme Court last year on Constitution Day, the Honorable President of India, on the occasion of her birthday, inaugurated Mitti Cafe at Rashtrapati Bhavan itself. However, there is a long way to go before we can truly achieve accessibility, autonomy, and equal participation for persons with disabilities. We still need accurate statistics of persons with disabilities, disaggregated along the various intersecting inequalities of gender, the urban-rural divide, and types of disabilities. A census up to date is the need of the hour. While government and private bodies are increasingly employing persons with disabilities, the workplace conditions are only slowly catching up. Technological solutions are sometimes prohibitively expensive and are unavailable to those who need them the most. Even as nearly 20 crore people live with psychosocial disabilities, we are ill-prepared to properly diagnose and accommodate their needs. Honest and deliberative communication of needs is central to evolving solutions for some of these issues. The Citizens Charter, the Handbook on Accessibility, and the Yes to Access app are certainly useful means to bridge these gaps. In conclusion, I wish to underline that the proverbial shameful walls of exclusion never